6:04 p.m. and I'd like to call this meeting to order of the July 22nd, 2024 Personnel Committee. I see that we have a colleague, Carlita Cotton, and myself in attendance, as well as a number of other non-committee members. Welcome, everybody. And is there any public comment?
None.
None. Okay. So we have the June 10th, 2024 meeting minutes. Have you had a chance to look at those? Any corrections, additions, edits?
Not that I could see.
Move to adopt the meeting minutes from June 10th, seconded by my colleague. And all those in favor say aye.
Aye.
It's unanimous. Great. So now the fun and exciting part of our meeting, presentation.
You want to just jump in? Okay,
I
Great.
think, do most folks know Ken? Have
You
met
know,
Ken?
I do know you, but I didn't recognize you because I've only seen you online.
Right.
So I apologize.
it's quite all right.
Yeah,
No
yeah.
worries. Absolutely no worries. Well, I will give a little intro. So my name's Ken Weinstock. I'm with a law firm called Canaan Escalera McHale in Hartford. I have had the privilege of being the town's labor and employment counsel for maybe about 10 years.
I think he hired you in
Well-
2013.
Okay, so 11 years. So time flies.
It does.
I have helped out either at the table itself or in an advisory capacity with negotiations. I spend most of my time representing public employers, so towns, school boards, housing authorities, et cetera, with their labor relations and employment law. And I negotiate contracts as a big part of that, and any grievances that arise out of that with their unionized employees. So I've been doing this for about 31 years. That's a little scary, but time flies in that regard too. Maria had reached out and said that she thought it would be a good idea. I did this some years ago, perhaps about 7 or 8 years ago, to give council members just an idea of what the negotiations are all about and kind of what guides you in that. So I will try to give you about a 10,000-foot overview about those today. Feel free to ask questions. This could be a nice little Bible for you in the future. If you want to refer to it down the road, you're welcome. And really, let's have a conversation. So any questions that you might have, please feel free.
Thanks. Oh, and Ken, if I could just add one
Sure.
other piece.
Yeah, of course.
So Ken also represents Region 19. So with our shared service model, that has worked out really nicely in
Yeah.
the past where I had helped Ken and the personnel committee out of Region 19 just working together on things like benefits proposals, wage proposals,
Yeah.
attending some of their negotiating committee meetings. So again, with our shared service model, having, that joint or shared council has been helpful at
Yeah.
times in the past.
And I've actually represented Region 19 since the 1990s.
Mhm.
So that goes back a long, long, long time.
Yeah.
19, like late 1990s.
Yeah.
So over 25 years. So I'm very privileged to have had that and see that whole experience play out. Okay, so let's talk a little bit about negotiations in the public sector. So the law that governs this is called the Municipal Employee Relations Act, as you see on the first page. Everything in the law comes with acronyms, if you haven't noticed, regardless of what the law is, right? So this is MIRA, M-E-R-A, not to be confused with MIRA, which is the what used to be the CRRA, the recycling folks in
Right.
Hartford, because that's MIRA with an I, M-I-R-A. So MIRA, the Municipal Employee Relations Act. If you're at all familiar with the public sector, there's the National Labor Relations Act and the National Labor Relations Board.
Mhm.
So this is kind of the baby version of that, but covers only municipal employers in the state of Connecticut and pseudo municipal employers like housing authorities and places like that. A critical thing to know about the law, unlike the private sector, no public employee in the state of Connecticut is allowed to strike or engage in a work stoppage in any form whatsoever. And that applies to DPW, our clerical staff, teachers, administrators. There had been, before my time, but a pretty bloody, believe it or not, strike by teachers from Bridgeport back in the late 1970s, where actually people went to jail and people got really hurt and bloodied in protests.
Wow.
And following that, the legislature said, no one's allowed to strike. So a big part of that I'll talk about, what replaces the right to strike for municipal employers, is this thing called interest arbitration, which is that if we can't resolve a negotiation, we go to this panel that decides our contract for us. In the private sector, you get the right to strike if your employee says leverage against your employer to try and force economic concessions, or the employer in the private sector has the ability to do what's called locking you out, where literally locking the doors to prevent you from coming to work and getting paid. Those two things don't exist in the public sector for any types of employees. We do it in a more structured and civilized manner than engaging in strikes. Of
Just
course,
to
please,
Interrupt you,
anytime.
only because we have a colleague who's remote. Is this available to send, not, if not now, then in the future, or included
Absolutely,
in our packet?
for
So
sure.
We can do that.
Maybe, please.
Yep. Definitely available electronically. Yeah, I apologize to Chris. Maybe I should have been new school and put it as a PowerPoint.
If you would give me an extra one, I'd throw it in his mailbox on the way home.
Oh, for sure.
Thank you.
Okay.
I'm actually hoping to make it to the meeting at some point, so, but I appreciate your remembering me.
So some important terms, I'm on the first substantive slide. So I already told you what MIRA, M-E-R-A is, the Municipal Employee Relations Act. And our NLRB, the National Labor Relations Board for this law, is called the SBLR, the State Board of Labor Relations. And what that agency does is hear arguments and allegations as to whether or not both the employer and or the union have bargained in good faith and complied with the collective bargaining law, just like what the National Labor Relations Board does. So that's their job. In order to be before them, you have to file, again, all these acronyms, an MPP, which is a municipal prohibited practice. That's a fancy way of saying the employer is alleged to not have bargained in accordance with the law, bargained in good faith. There's also an MEPP, which is an employer's ability to file that same charge against a union. So unions can file charges against the employer for not bargaining properly, and an employer can file those same claims against the union if the employer believes that the union has not engaged in that good faith bargaining. And I'll get into what good faith bargaining is in a little bit. It's actually far more basic than what most people have ever thought, but I'll get to that in a minute. I want to keep you hanging on in suspense for what that is. Then we have another agency at the state, the SBMA, which is the State Board of Mediation and Arbitration. All of the contracts here and most municipal contracts call for that if we have a dispute under the contract, a grievance, that gets heard by the State Board of Mediation and Arbitration.
Why do you say most?
Because
And not all.
Good question. So the parties have the choice through negotiation as to what dispute resolution body they want to have.
Oh, okay.
Most have the SBMA because it's the least expensive mechanism available. So there are a lot of different dispute resolution services. There's something called the AAA, the American Arbitration Association. There's another federal entity called the FMCS, the Federal Mediation and Conciliation Service, that provides arbitration, grievance arbitration. And there's a difference because I mentioned interest arbitration earlier. When there's a violation under the contract, that's a grievance and you go to grievance arbitration. The state has a filing fee of $220, I believe it is, per party. So the employer $220, the union $220, and you don't pay anything else. A lot of these other entities, there's a filing fee that's similar in cost, and then you pay for the arbitrator services on a day-to-day basis.
Got it.
And that tends to run in the $2,000 a day range, and a day is 6 hours. So most municipal contracts have this service because
Right.
it's the least expensive.
That makes sense.
And so the state appoints the neutral arbitrators. It's a 3-person panel. It's kind of a great spot for retired labor relations people because you have a neutral who's appointed to the panel by the governor. And then you have management arbitrators and labor arbitrators. And management arbitrators could be someone like me in my retirement years typically, or a former or current labor person who works with the unions, or again, someone who did it as a profession and now has retired, and they serve as the panel to evaluate whether or not that grievance has any merit. Not surprisingly, it's really all about the neutral person in deciding the dispute, although periodically you will have a dispute where you get a 3-0 decision where all 3 panel members agree that either there was or there wasn't a violation of the contract. And grievance arbitration under the SBMA is again, and I mentioned this, whether or not the contract itself was violated. But a prohibited practice before the State Board of Labor Relations, the SBLR, is whether or not we followed the law correctly in how we bargained. So those are slightly different things, and they do slightly different things.
Just gonna
Please,
jump in.
of course.
Regarding the mediators. So under our collective bargaining agreements, as Ken indicated, we do use, I think it's the ADRC for a mediator for grievances, particularly in regards to a grievance arbitration on terminations. Many years ago, there was an issue with some pretty significant delays in being heard before the SBMA, and months and months and months before you would get a decision. And for grievance terminations that are, going to arbitration, if somebody is to be reinstated by an arbitrator, right, the longer they're away from work, the more
Mhm.
disruptive that becomes. So timeliness,
Right.
even though it's more expensive, timeliness is often just more important. And it's
then-
so rare for us to end up in arbitration, but at least during my previous 11 years here, I think we had two grievance arbitration cases on terminations that we used I think the ADRC and those cases, just again for a bit more of an expeditious proceeding.
And we might save ourselves on back pay if we lose.
Correct.
Right.
By having it go that much quicker.
Right.
There's other pluses. So some municipal contracts have gone in a similar route. There are some pluses to not using the SBMA, the State Board of Mediation and Arbitration. Here's why. You don't know who your arbitrators are
Right.
until the day you walk into the hearing if you use the SBMA. If you use a private arbitration service, then the 2 parties get to strike names,
Right.
and you can actually oftentimes come to an agreement as to who that individual will be who will hear your case. So it gives you a little bit of self-control over perhaps how the outcome will be or how the case will be heard. But at the SBMA, it's the luck of the draw. So you literally don't know until the morning that you walk in who your panel is. And like everything, some people are better than others. Some people understand the process better than others. You'd rather have your case before some versus others, and you don't know that until the minute that you walk in.
Right.
So kind of being the master of your fate perhaps is a little bit better when you have some say in who gets selected to be your neutral. So there are advantages. I also have another bullet here. This is just good for folks to know. So without going into a big constitutional law discussion, but all of our public employees, and this applies not only here in Mansfield, but at the state and in every union contract, can only be terminated for what's called just cause. And by having a collective bargaining agreement that says you can only be terminated for just cause, the US Supreme Court, and again, I'm giving you like a 50,000-foot overview, has said that creates a property right, a constitutionally protected property right in your job, such that there are certain procedures that are necessary before that right can be taken away. So no different than any other constitutional right that you have. So, so the idea of at-will employment, which for those of you in the private sector is very common, doesn't really exist in a union contract in the state of Connecticut, because just cause at will means you can be terminated for any reason or no reason at all, as long as it's not a discriminatory reason. So the employer could just say, you know what, I just want to go in a different direction, and that person can be terminated if it's at will. If you're just cause, you actually have to have significant reasons and the ability to explain why. And then on top of it, there are these constitutionally protected processes. I mentioned this thing called Loudermill. Just like acronyms in the law, there's things that come about as a result of cases that are known for what the case name was. So the case involving Loudermill dates back to, I believe it's 1985 with the Cleveland Board of Education US Supreme Court case. And what that said was, if you're a public employee protected by just cause, you have a property right in your job. And before that can be taken away, you actually have to have process both on the front end before the decision is made, as well as a meaningful appeal process on the back end. So what is the process on the front end? The process on the front end is that we have to give, if we're going to terminate someone, and it trickles down to any time that we deprive a public employee of any kind of economic benefit. So if we suspend them, if we take away a couple of days of sick time or something, if it's any type of deprivation, any type of quantifiable thing that we're taking away, they're entitled to prior notice and the reasons why the town is contemplating either taking away that benefit or terminating them or suspending them. And then on top of it, they have the right with a union representative to argue their case before the decision maker comes to the decision. That's what the Loudermill case is about, this prior process that exists before the decision is made. But then you also have to have a meaningful appeal on the back end, and that's arbitration. And what Loudermill said is that the meaningful appeal on the back end can't be a court case, similar to what Maria was saying, a civil action, because it takes years for a civil action to percolate through the court system. And even though with delays and all, you will typically have a grievance arbitration within 6 months of the decision. And the court said that's more timely, that's a more timely remedial scheme for the person to get their justice and to get a decision on what the action was that the employer took. So, and you're not in, you, the council, are not in the grievance process, but the grievance process, the final step locally is with the town manager. And then after the town manager, who could also be the person who decided on the termination, that's not unusual. After the town manager, then it goes to arbitration outside of the town. And then the last piece, and I'll get into a little bit more about this, is interest arbitration. And it's hard because the terms are similar. And that is, as I mentioned before, how we settle a contract if we can't do it ourselves voluntarily. If we are stuck on a few terms of our contract, again, instead of a strike, instead of employees or management being able to take into their own hands whatever kind of industrial justice that they want to do, there's actually this whole process, again, with an arbitration panel. And I'll get into what that is at the very end of the points that I'm going to go through. All right, so bargaining in good faith, what does that mean? It simply means that the parties have to be willing to meet at reasonable times, confer in good faith on mandatory subjects of bargaining, and that if they come to an agreement, they have to execute a written contract that incorporates all of those agreements. And a critical thing is the last bullet, that to bargain in good faith does not mean that you have to compromise at all. It doesn't mean that you have to agree to anything. You have to be willing to meet at reasonable times and be open to discussion about whatever the issues are, wages, insurance, other benefits. Some people think that bargaining in good faith means I have to agree or I have to give. You actually technically don't have to give. You don't have to agree. There's obviously benefits to agreeing voluntarily, management wants things, the union wants things, so obviously the trick is kind of where do we meet in the middle to try and get those things done. But this at its very core is what we mean by bargaining in good faith. So what has to be bargained? The next page. So there are mandatory subjects of bargaining. The law is really precise about this. What we have to bargain, the law says, is wages, hours, and other terms and conditions of employment. Those are the mandatory subjects. Wages, I think you know what those are. Hours are everything from what schedule to overtime, start time, end time, the length of the day. Whether there's mandatory overtime, like for our folks in public works to plow streets or react in emergencies. So those are hours. And then other terms and conditions of employment, this is kind of the catch-all. Everything else that's a benefit or a cost, that's what's within that: insurance, paid time off, holidays, the grievance process, what steps are in the grievance, what arbitration panel we use for a grievance. Those are the terms and conditions of employment. Do we give a longevity bonus? Do we pay $500 for someone who's been with us for 10 years? Those are other terms and conditions of employment. And you can only imagine that there are dozens and dozens of things that over the last 50 years of this law being in place that the state board and others have kind of developed what that all means. Permissive subjects, kind of what it sounds like. Those are things that we can choose to bargain about, but we don't have to. And those are typically things that rest exclusively in management. What's an example of that? Layoffs. The decision to lay off, the decision to reduce our resources is a decision that rests exclusively with management. We never have to bargain about that. So, you know, we hit tough economic times. We have some other challenges. Now, having said that, years ago, during the Great Recession, there were agreements made that employees would either take reductions in pay or wage freezes in exchange for a no layoff guarantee. So employers didn't have to bargain about the no layoff guarantee because employers always have the right to lay off. But you can choose to bargain about that, especially if you're looking to achieve something else with it. So those are our permissive subjects. And then illegal subjects of bargaining. Oh, other permissive subjects too are things that are governed by statute that we don't have to bargain about. Are you Chris?
I am Chris.
Nice to see you. I'm Ken.
Hello, Ken.
Thanks for coming.
Thanks for your explanations.
Good.
It's very set on their pacing.
You can understand it?
Yes, and remembering it might be another.
All right, good. Hopefully I don't talk in too much legalese because that can just make it that much more challenging. We're on slide 4. And then illegal subjects, what are those? Well, so things like recently when the legislature increased the minimum wage in a very progressive manner, I had a number of contracts in the schools where cafeteria workers, for example, were not making $15 an hour. But the legislature said effective on X date, minimum wage was moving to $13, $14, $15. So if the contract said that when minimum wage was supposed to be at 15, our contract said $13.50, that's illegal. We couldn't stand behind that and go, oh, but we agreed to $13.50, even though we had no idea that the legislature was going to rapidly increase the minimum wage. We never have to negotiate about illegal subjects. So what additional things, this thing called impact or effects bargaining. So these are things where management has the right to make the decision, but the impact of that or the effect of that we have to bargain. So you're probably thinking, I have no idea what you're talking about. Go back to my example of a layoff. Management always has the right to lay off people. So we never have to bargain about that, but we do have to bargain the effect of that. What is that? What order? Who goes first? Do we do it by job classification or by seniority throughout the bargaining unit? Do we have the ability to do it because we have 25 different jobs in town hall, let's say? So if it's by job classification, you may only have one person in a classification. You could have 2 or 3 people in a classification. So what's the order? Do people have a right to be recalled to the job? So that if the need for laying people off is eliminated or goes away, do people have the right to be able to come back to that job? Those are all the impacts and the effects, even though the decision to lay off is exclusively management's. And to some degree, this is kind of a case where the exception at times can swallow the rule, because you cannot implement a layoff until you've negotiated the impacts. Who goes first, whether people can come back, is it by strict seniority, et cetera. Some things like this have already been negotiated in our contracts. So our contracts, not unusual, have a layoff article that explains all of this, because that is very typical when something like that happens. But a good recent example of where things had to be negotiated and the impact was with COVID, when we had to close town halls and things like that. So people working remotely, how did we put that into effect? Those are things that have to be discussed and dealt with the union. All right, so contract ratification, next slide. This is where you folks on the town council come into play. So your job is to actually, well, I was about to say to approve the contract, but legally that's actually not the case, believe it or not. Your job is either to reject or not reject the contract. That's what the legislature has said. There's actually no affirmative obligation by the town council to approve a union contract. The contract, as you see by the first bullet, has to be submitted to the legislative body of the town, in this case, the council, within 14 days of an agreement. Now, when that 14 days triggers, usually the parties agree when that should come into place, and that's usually after a full tentative agreement that outlines all of the terms and details of the contract has been agreed to, and everyone agrees that that captures everything. Within 14 days, that has to be submitted to the council. And then within 30 days, as you see in the second bullet, agreements, this is literally more or less right out of the statute, are considered approved unless the legislative body rejects them within 30 days of submission. So a lot of municipalities believe we have to approve the contract or not approve the contract. Technically, your only obligation is to reject the contract if you don't like it. It's not to say that you don't affirmatively approve it, but that's actually not required under the law. And if it is rejected, then mandatory binding arbitration would ensue, or the parties could go, and that's interest arbitration, which I'm going to get to in a few minutes, or the parties could try to negotiate what the concerns and issues are. So just taking a simple example, let's say that the wage increases the council thought were too high, that were agreed to at the table, and the contract gets rejected. The parties could try to work that out amongst themselves. But if not, if both sides don't want to do that, then they could say, no, we're not talking anymore. We're going to interest arbitration to have a panel of arbitrators decide what our contract's going to be. Typically, the union ratifies first before the council does, and that's very typical throughout the state, that the unions approve the contracts first. And that kind of makes sense only because you're the funding body, you're the body that really implements everything in the contract. So why go through that vote if you're not sure if the employees have approved that? And the union has to approve a contract by a simple majority. So you could have a whole bunch of people who don't like the contract, but if it's a group of 30 and 16 vote in favor and the council approves it, you have a contract. Simple majority approves the contract. Okay.
And can I,
Yes.
ratification, could you also just mention their role in Board of Ed contracts and the ratification?
Yes.
process?
Oh, thank you.
Thanks.
Right. So for Board of Ed contracts, for certified employees at the Board of Ed, those are teachers and administrators only. The town council, a similar thing, the contract. If the Mansfield Board of Education is negotiating with their teachers this year and they reach an agreement, the law says they have to file that agreement with the town clerk's office. And the town council, as the legislative body, again, has 30 days to reject the contract. So even though you're not directly involved in those negotiations with the teachers or the administrators, again, if you believe that the contract kind of oversteps its grounds, you as the council, as the legislative body, do have the ability to reject the contract. Again, some councils like to actually affirmatively approve the contract. That's not what the law says. It automatically is approved if not acted on in 30 days. I should wind back to that should probably never, well, it could happen, but one of the other pieces that go into place is that on the education side, the Board of Ed is supposed to notify the fiscal authority in town that they are about to undergo negotiations with their teachers or their administrators. And it gives the town the ability to educate them about issues that the town is concerned about. So hypothetically, if health insurance costs have really run away and our Board of Education happens to be the only group that still has this plan, which has cost us a lot of money, the Board of Education is duty bound by law to first notify the town before it starts negotiating and to get feedback on the economic situation in the town. So if the council and the Board of Finance have given that before the start of negotiation and the board chooses to ignore that and comes back to you with, hey, the same insurance plan, business as usual, you, the council, then have the ability, if you so choose, to reject that contract. And then the same thing happens. It goes back to the parties to talk further, or it goes to arbitration to get the contract resolved. Does that cover everything? Yeah.
Thank you.
Just a trivia question. Is the union simple majority rule a state law? Or can a union amongst itself say, amongst its members say, we will have a 2/3 or whatever?
Good question. It's governed by the union bylaws, but to the best of my knowledge, they're
That's all
all
you've ever
simple
seen.
majority.
Interesting.
Yeah. Yeah, good question. Before I get to the strategies, let me put a hold on that for a second. I just don't want to go too long. I want to jump ahead one slide to mediation. Because the strategies is more about the folks at the table, but I'm happy to go back to that. So if we don't come to a full agreement on the contract, there is an intervening step before going to interest arbitration and spending the time and money, and it's quite labor intensive to have a panel decide what our contract terms are going to be. The state offers as a free service mediators to assist the parties in trying to come to an agreement. They are state employees, trained mediators. They have no stake in the outcome. They don't get a raise based on how many contracts they help settle, but they are supplied by the State Board of Mediation and Arbitration, that agency that I talked about at the very beginning. And their job is to come and, just as I said, help the parties. It's off the record. None of it is binding on the parties. You can talk about different things. You can offer different things that can never be talked about later on as a way to try and resolve the contract. So if you're at loggerheads on 2 or 3 issues, you have a mediator come, and oftentimes the mediator will talk about, whoever it is. I've had it with my clients, you're really not with where the trends are. You're seeking a wage increase that's just way below where the average municipality is negotiating and agreeing to. So that's a bit of an unreasonable position. On the flip side, the union could well be at a 5% wage increase. And the mediator could say, there are no settlements in the state of Connecticut that give a 5% wage increase. So you have to get more reasonable. At the end of the day, you could still not have an agreement, but about 85 or 90% of the time, the mediators do get the parties to a place of an agreement. Again, because they are not self-interested in the outcome.
Right.
And they're very familiar with the arbitration awards and decisions because they come out of their office, so they read them all. And so they can say, you know, there have only been 4 arbitration awards this year, and there hasn't been one that's awarded wages above 3.5% in any given year. And hey, union, you're stuck at 4%. And if history is any indicator, you're not going to, you know, fare so well in arbitration. So it oftentimes helps. If I do my job, then you should have already known that, and you're just rehearing what the mediator is telling you, but you're already aware of it. I think that it's a lot more helpful on the employee side because sometimes the employees don't trust their representatives, that they're necessarily telling them everything about what they should be to try and get an agreement. But when you would have someone from the state totally uninterested who comes in and says, you know, this is where things are, it can help a lot to have those individuals say, okay, I get it now. So going forward, interest arbitration, how does it work? So I've talked a lot about interest arbitration. This is if we don't get a settlement either voluntarily or with mediation. So it's usually a 3-person panel, the same way as grievance, where you have a neutral, labor arbitrator, and a management arbitrator. You do get to pick your neutral, unlike grievance arbitration for your contract dispute. There are some statutory factors. The legislature has actually laid out what they're supposed to look at. I'll tell you those in a minute. But the critical thing is the way that this works are the last 2 bullets. You submit an offer, a last best offer on each individual disputed issue. So if you have a 3-year contract and you haven't agreed on wages, each year of wages is a separate issue. If you have health insurance and how much people are going to pay for health insurance each year, each one is a separate issue. And the arbitrators choose issue by issue, and they're only allowed to choose either the offer of the union or the offer of the employer. So I've been talking about wages. The union's at 4%, we're at 2%. The arbitrator cannot say, boy, 3% looks really fair. I'm going to say that your wage increase is 3%. Absolutely illegal in the state of Connecticut. There are some states that allow the arbitrators to fashion what they think is appropriate, but the arbitrators literally choose either 4% or 2%. So there are some risks and some real unknowns going to arbitration, because I know you'll find this surprising, but no one wins it all in arbitration. So, even I'll get to this in a second. One of the statutory factors is the financial capability of the municipality. So the wealth rank, we have 169 towns. Well, the city of Hartford is always 169th. I've represented Hartford, and they haven't always won every single financial issue, even though at least by law they should, because the primary statutory factor is the financial capability of the municipality. So the trick is trying to figure out, what are you going to win and what aren't you? Why do that if you can kind of figure out your own fate, right? So the next slide, so the priority factors that are considered, I just mentioned one of them. The statute says there are 2 priority figures. One is the public interest, and the other is the financial capability. What's really nice is that the legislature did not define for us what is the public interest. So we ourselves have to define it for the arbitrator. So the public interest today in the town of Mansfield could be very different than it was 10 years ago, right? Hypothetically, given the workplace situation and how difficult it is to fill jobs, the public interest could be, gosh, we have 10 vacancies that we can't get filled. 10 years ago, the public interest might have been, oh my God, we can't raise taxes on our citizens because we're in the throes of the Great Recession. So it changes depending on what the situation is. And obviously the public interest in an educational area, so if you're with the Board of Ed, can be very different than the public interest on the municipal side of things. They can be very similar as well, but they can for sure be very different. And the parties argue what is the public interest to the panel, and the panel decides what's the public interest. So one of the 2, and that's the first listed priority factor, is the public interest. It's not defined, and it's different in every case. So thanks to the legislature, you really don't know what you're shooting at.
Yeah.
And then,
Flexibility.
yeah, a little bit. And then the last slide. So what the law says is that in light of those two priority factors, public interest and financial capability, the panel should also look at these things. The negotiations, so like, where did the parties start? Where have they ended up? The interest and welfare of the employee group. Now, strangely, they don't have the interest and welfare of the municipal employer. So it's very hard as the employer to argue this one on most things that are beneficial to the employees, right? That's kind of an already stacked deck in their favor. Changes in the cost of living when you're dealing with financial things, that's very different and difficult now compared to what the cost of living was 4, 5, 6 years ago, right? So that's difficult. The next bullet, though, this tends to be the most compelling. Existing conditions of employment for the employee group and similar groups. So let's say you're firefighters. It's pretty easy to compare
Yeah.
firefighter to firefighter. So what kind of schedule, if we're debating about a schedule and wages and how many personal leave days they get? Well, what do other fire departments get? What do other municipal employers provide through negotiations to their firefighters? Now, the trick is, who do you compare yourself to?
Right.
It's supposed to be of similar
Similar.
groups. So is that similar in terms of population, area, wealth, tax base?
Building structures.
You get to decide. So the legislature didn't tell us what the similar group is. We get to argue it to the panel as to what should be the similar group. And you know, Mansfield's a pretty unusual place, right? Because you have a very challenging tax base with Yukon here. So much more difficult than your run-of-the-mill municipality in the state of Connecticut, where you have a greatly reduced tax base, yet you have a large population, you have critical services that need to be provided. It's a very unusual place. So who do you compare yourself to? Right? And that's the trick of the people in my shoes, is to make that argument.
Yeah, and Ken, if I could jump
Of
in.
course.
A lot of times, when we look at our similar groups, whether it's for classification and compensation work, for negotiations purposes, a lot of times we'll look at our, some of our immediate neighbors geographically, but then we
Mhm.
also expand to the council manager communities in the greater Hartford area, because again, the form of government, who we attract for talent, a lot of the financial policies and practices that we have, it's very, it's very similar in the professionally managed communities, and we really do trade talent. And so that, I think, has served us really well when we're trying to make an argument for our similar groups, as we say, well, we look in our immediate geographic area, but then we expand that a bit to our comparable, communities, again, professionally managed communities in the greater Hartford area.
Right. And you could imagine for the city of Hartford, who do they, if they were to take abutting communities, those are all significantly wealthier communities, perhaps with the exception of East Hartford. But do you really want to compare yourself to West
West
Hartford, to
Hartford.
Glastonbury, to Farmington, to,
Avon.
right, to Avon, et cetera? Of course, you're going to look really in a challenging place. And can you pay the wages that those communities pay? So the trick is, who do you compare yourself to? And oftentimes a place like the city of Hartford, when I've done it with them, I compare them to the other large municipalities in the state. Because shouldn't you compare them to Stamford and New Haven and Waterbury and Bridgeport, right? Because they really don't share the same characteristics as Farmington and Glastonbury. So the panel then decides, is that a legitimate and credible comparison group? And you can only imagine that that's very compelling, because if you show what 20 municipalities do in terms of schedule and settlements on wages and other things, that, no arbitrator wants to kind of buck the road. They kind of want to be where everybody else is, right? And going all the way back to what I said at the beginning, because this is supposed to be a substitution for the right to strike as a way to settle things, no arbitrator wants to be on the extremes, because the reality is, as a result of a strike, you move to the middle, right? Perhaps the union and the employer are way out here when they first start striking. If you remember the recent Big Three strike, And, the union wanted all of this stuff about pensions and a 32-hour work week and all these different things. And management wanted different things that were totally restrictive. And where did they end up? They ended up much more in the middle. And, I read a lot of articles that, the union had promised too many things. And where did they settle? They settled still with the employees getting some good things, but not to the promises that were made. So if a strike is supposed to drive you to the middle, an arbitrator wants you in the middle as well. They're not going to do anything that's way too far afield from what is going on out there. And I'll go back to that last slide very quickly. The earlier one, which is what do we look at for strategies? That's number 7. I'll ignore ground rules for now, but things like what do things cost? What are we proposing and how much does it cost or how much does it save us? As the employer, that if we want to realize cost savings, we should know what those savings are. So if we want to change an insurance plan, how much is that going to save us? If we want a different schedule, how much should that save us in overtime? Because we're now doing a different schedule. We should probably share some of that comparison data both amongst ourselves and perhaps with the union, because if it's compelling enough for us that we're saying, we really think that this should help drive us to a particular place, why wait until much later in the process? I kind of look at it and say, no harm in showing the employees that, hey, look, we just want you to be where everybody else is, and this is where everyone else is. If we want to look at some non-economic issues, some operational things, if we think people are abusing time or extending holidays and other things with excessive sick leave or personal leave, we should be able to show that. We should have proof of that because we'll need to show that to the arbitration panel. And then the last piece is everything that we do at the table can be talked about later. It's never off the record unless we say it's off the record. So everything that's said, everything that's put forward at the negotiating table in proposals can come back to bite you depending on what it is. However, you can do what's called talking off the record. It is an amazingly respected process that in a negotiation, the union and management can say, let's talk off the record, and whatever is spoken about there can never be spoken about again. And it's bad faith bargaining if it does, and it's actually held very sacrosanct. So people respect what is off the record. And mediation for your contract is off the record. So whatever's done through a mediator to try and resolve the contract also can never be discussed with an arbitrator or anybody else. So I condensed down for you what I do in about a 3 or 4 hour session when I train HR people and labor people. But I don't know if you have any other questions, but hopefully, if not, then it was helpful. Please.
I'm curious if there are, you mentioned about, it's management's prerogative to lay off.
Eliminate jobs.
Eliminate jobs,
Yep.
eliminate categories of positions.
Sure.
So what are the opportunities, realistic opportunities for reset? As in, this has just gone too far in the wrong direction. We are paying the pencil sharpeners an absurd amount of money. They've got a ridiculous, benefits program that the town cannot continue to pay for. And yet the mediator can't be convinced. Can I, or arbitrator or whichever, I'm not using the words exactly.
No, it's okay. I follow what you're saying.
Can the town eliminate that position and start up a new writing implement division or something like that? What are the realistic opportunities for, again, reset? Is
Right.
what I'm thinking of.
It's super fact sensitive, but there are ways that you can reorganize how you do things. I've been through situations where if the pencil sharpener is really not needing there's not enough work for the pencil sharpener for a 35-hour work week or a 40-hour work week. So we combine either combine positions or give additional duties because, things do change, things modernize, things develop. I always use the example that when I first started doing this 30 years ago, we had no fax machines. Nobody uses a fax machine anymore. We had no email. We had no Excel spreadsheets. We had no word processing,
Right.
right? So if I'm a clerical person, my job has changed tremendously. And the productivity that we expect from that position.
Mhm.
Now, if we have a position that really has outlived its usefulness or isn't particularly productive, and we can either morph that into or combine that with another position or restructure that position, there's a lot that goes into it, but we're allowed to do that.
I'm actually thinking more of a reset, of a delete that, because these guys they get special gloves and the new people wanted gloves. These guys get special chairs and enough of that. We want to be done with that. And that's the kind of thing they're not going to want to negotiate out of the contract.
Right. If it's too similar, then it'll create some issues with the union. If really what you're doing is trying to eliminate that position because you want to avoid bargaining about it, but then the position that you create really does walk, squawk, and talk
Yeah. I'm
like
not-
the former position, then that, so again, the devil's really in the details and the facts. It's not to say that it can't be done. Where I thought that you were going was about subcontracting, because I get asked that question a lot. The decision to subcontract is a mandatory subject of bargaining. So if we decide, if we have custodians who clean our bathrooms and hallways and our meeting rooms and those types of things, that's the typical place where it's talked about. And we decide, we can do this cheaper with John's Cleaning Service, who we know, works with all of these other folks in Store Center. We are not allowed to do that until we negotiate that. And you can only imagine, there's no union that wants to negotiate themselves out of
Right.
business, right? So there's a lot of difficulty with that depending on what it is.
Hmm.
So however, part of what can get you to that place is, like, a good example is during the Great Recession, in 07, 08, 09, when things really did crash, that gave employers a good opportunity to say to the unions, look, we have to streamline, we have to get down to real critical mass. We have to figure out a better, more efficient way to do things. And if that saved more jobs than it cut, you would oftentimes have agreement from the unions that that was okay to do. So again, it's very fact sensitive, but there are ways to do it.
Mhm.
It's not to say that it comes easily.
Mhm.
I've had a few employers who try to get cute because they eliminate a job because they don't like the person, or in lieu of going through the discipline steps and the termination steps that I talked about, let's just eliminate the position. And then 9 months later, they recreate almost they call it something different,
Yeah.
but it's really effectively doing what the other one was. It's form over substance is what the state looks at. They're not going to be bamboozled because we called it, refuse engineer. Now we're calling it, engineering of,
Sanitation,
you're right,
design.
sanitation, what have you. They're gonna peel back the layers and really see what it's all about. It's a good question.
You asked it.
No, you asked it.
Well, thank you so
Thank you
much,
so much.
Attorney Weinstock, for
Yeah.
your presentation.
Thank you.
And
I appreciate the opportunity.
I have studied employment law. I work in the state Rockville courthouse.
Oh, okay.
So, but I still found myself learning some stuff and very informative. So
Great.
Thank you.
I'm happy to come back if you ever need a little more information or whatever. So, by all
Might be a
means.
Good idea.
Yeah, I certainly don't want to wait the 7 to 8 years or whatever.
Well, yeah, a lot of faces that I've never seen before. So it's nice to see you all.
Yeah.
All right. Well,
Positions are the same now,
excuse me?
same positions.
Oh, there you go. Just different people in them.
Yeah.
That's great. Well, I probably ran a little bit over, but thank you
Thank you.
so much.
Thank you so
All right.
much. This
Thank
was
you.
very
You're welcome.
helpful.
Thank
Good.
you. Thanks. See ya.
Okay. Do you still want me to send that to you electronically?
Yes. please.
Okay,
That'd
I'll
be
do
great.
that
Thank
tomorrow
you.
morning.
Thanks, I
Okay,
appreciate it.
great.
Thanks,
Take
Ken.
care, folks.
Take care.
Thank you.
Have a nice evening.
You as well.
Okay.
Okay, so we can do super quick.
Just real quick, I just had an update for the town manager performance review instrument process. We had a question as to whether or not the Survey Monkey would allow participants of the survey to participate anonymously. And one, we were able to log into the account, if I understand this
Yes.
correctly.
Yeah, so everything is all updated, the form is updated, the contacts are updated, the emails, the email reminders, everything is scheduled, so we're in good
Great.
shape.
And this, what you was passed out is confirmation that all the identifying information will not be associated with the responses. And so that if someone were to respond, their name and information is not attached to that. Which I think from prior discussions, and I agree, it's important so that our colleagues feel they can provide honest and full feedback to the town manager's performance. And we're still on our path to rolling it out next month.
Yes, so it's scheduled to release on August 2nd, so you'll receive an email. It'll look like it's coming from me. You'll receive that email, it'll have a link. The survey will be open, I believe, from August 6th to the 16th, but the email will have those instructions for you. Sam's contact information is in that email if you run into a problem or have an issue. But yes, so it should be scheduled to be all set, and Ryan is working on his self-evaluation as well as an update on his goals. And he's going on vacation, but he will have that for you the week of July 29th. I believe he's back on the 30th, and I think we had said that we would try to get all of that information from him to you no later than August 1st. So he's also on track to get that information to you as well.
Yeah, thank you for the update.
Yeah,
I
well,
only have one question. You mentioned the email reminders and stuff have been embedded already.
yes, so there's an option where you can set up in SurveyMonkey, it's just an automatic reminder. So for example, let's say, I don't know, 5 survey respondents have not, yet responded. And so you can set an automatic reminder 3 days out, 7 days out, 10 days out. You can just pick a date. Usually in the past, we would do it a week out, just as a reminder, like,
Mhm.
so you're not sending it to the whole group, right? It'll just automatically send it to folks who have not yet responded.
And how do you know if they've not responded if you don't have their identifying information?
I just don't think it's, and correct me if I'm wrong, I don't think it's attached to the responses. So if there's 9 of us and 4 respond, the fact that those 4 have responded is logged, but what they've said is not.
It's not.
Gotcha,
for them.
gotcha.
So that doesn't match, but
Mm.
so in theory, there's, we want to make sure we don't send it up too quickly because we don't want one person to have responded and then we know who that response or, the responses are before that reminder goes out. So when is it gonna be?
I believe we usually do it at the halfway mark, so about 7 days in, but.
Oh,
past-
7 days in.
Right,
Perfect.
but in the past, sometimes Tony would just give me a heads up when she was the chair previously of the committee and say, hey, I
Okay.
checked and we still have, 4 people who haven't responded and there's only a day left. Can you send another automatic reminder? So occasionally in the past, we would send, multiple automatic reminders if Tony was concerned about the
Okay.
response, right? And then one particular instance, I think she did have me reopen it and extend the deadline just because it was vacation schedule. I think some folks have gotten behind schedule. So that's just something, Sam can instruct me if, you feel like
Yep.
you just don't have enough responses and I can just help to send out the reminders.
That's cool.
Yeah.
I think the last
Okay.
meeting was the tool complete. I mean, it wasn't, or I thought it was still a draft.
It is.
At the last
Oh,
meeting.
thank you.
Yes.
So the last meeting, as I understood, we didn't have any form or edits to the questions themselves. It was anonymity was the main concern.
What was,
The,
Anonymity, this not matching the person with responses.
I thought also that how the scale was presented, whether it was always presented in the same way where a high number meant the same thing on each question.
and so there was a scale question, but that was, my understanding was that was alleviated by the fact that there's a text box that you can freely respond how you are trying to indicate your answers.
So 5 point Likert plus
The comment
Um,
box for each question.
yeah,
Right.
gotcha.
Anything else?
You know what I could do? I could circulate, now that the form's been updated in the system, I can download it into a PDF format and it essentially prints. No, unfortunately, no, but it does print in a way that would at least resemble what somebody would be looking at on the screen. So I could just download that and send it
I would love
to
that.
folks.
Yeah. I would love
Whatever's
that.
helpful.
Would that be
Yeah.
helpful?
Yeah, that'd be very
Okay,
helpful.
sure, I'll make a note.
I am, I'm also not, as you know, not a member in this. The minutes themselves, the date in which you held your meeting,
Oh, was
Um,
it
you
incorrect?
had, the 10th in the document and the
Oh,
20th on the meeting.
This is the 20th at the top.
We did meet on the 20th because
Oh,
of
that's right.
my medical issue, so we had to
did
reschedule.
Yeah.
But was there June 10th somewhere else in here?
Yes, in the agenda, that
I didn't
it
catch
stated
that.
June 10th.
Oh, the agenda itself.
Oh,
Gotcha.
thank you.
You're welcome.
Yes, yep, June 10th was our originally scheduled date, which we had to postpone.
Right, we're good.
Yeah. It's like, oh no, did I get it wrong in the minutes? The agenda, thank you.
I'm gonna move to adjourn. Do you get to do that here?
I move to adjourn.
Seconded. All those in favor?
Um,
Aye, it's unanimous.
All right.
We're out.
Right.
Thank
We're-
you,
we're late.
everybody,
Well,
sorry.
they can't start without us. They don't got quorum.
Yeah, they can't. They would say,
You got it. Oh, in there.
Right.
Yeah.
Great.
Right, thank you.
You're welcome, thanks, everybody.
Thank you so
Yeah,
much.
you're welcome.
Yeah.